section, we thought it'd be good to talk about power of attorney, which is something we've referenced before. And it might be helpful just to kind of outline what it is. So
there are two types.
Yep.
There's one for health and welfare, and there's one for finance. Every solicitor I've ever met has told me I only need the finance one, which is not true.
Okay.
So the finance lasting power of attorney basically gives you the right to handle transactions on someone else's behalf. And this doesn't necessarily have to be when they've lost the power to do that themselves. So, for example, one of my family made a lasting power of attorney for one of the others to handle his financial affairs whilst he was out of the country for a year.
And that can be
that simple.
paying bills, entering into contracts. You've basically got the full ability to act as that person in any financial dealings.
And then the health and welfare one is the one we often ask for in care situations, where somebody has the right to make decisions about somebody's health and welfare. That can only kick in if that person has lost capacity to make those decisions for themselves.
So you can appoint someone to have power of attorney, but until they lose capacity.
So capacity might be that someone's unconscious. So they go into a coma, and if they've appointed someone to be their attorney for health and welfare, that other person can make that decision for them. So it doesn't necessarily mean that they have dementia or something else. It can mean a brain injury of any sort or description, from a road traffic accident right the way through to Parkinson's, to various other things that people can have. So the health and welfare one is the one that kicks in when someone cannot make those decisions for themselves. And that enables people to make decisions about where they should be looked after, who should look after them, do not resuscitate decisions about what medical treatment to have or have not, and where they can be cared for. So all of that is contained within that. The finance one can also look at how much things cost. So is it expensive to put somebody into a care situation, and do they have the funds for that, or whatever. So again, both can work hand in hand. Solicitors I've used have always said, don't do the health and welfare one, because you're all going to agree it's all going to be fine. Well, that's not always certain, and I think from the point of view of making those decisions, often it's easier to have decisions made where you know that you have the right to make those decisions. Hospitals will often look at people as next of kin, but if they don't have the power of attorney for health and welfare, they may then say, well, it's our medical decision that X will happen or Y. So those are the two forms of power of attorney, and they're overseen by the Court of Protection.
So the Court of Protection is a body that if something's going wrong, you can appeal to them. They can apply a number of sanctions, including the ability to remove an attorney or replace them. And I suppose one of the key questions, particularly when we're looking at it with a lens of family conflict, is who the attorneys are. So you are giving that one individual or those people the power to make those decisions. So it could be tempting to say, let's say you have 3 siblings, that will make those 3 siblings the attorney, but they have to be able to then agree and make collective decisions. If they start disagreeing with each other, you can get into some real problems.
And sometimes there can be times when you think, actually, I'd rather one person have it. So, for example, at the moment, I have power of attorney for my foster mum if my sister isn't around.
Okay.
So she's made a power of attorney so that if she can't make a decision and I'm there, I can make a decision on her behalf. That's the kind of power of attorney she's got. Now, having said that, we've been discussing recently whether we should both have power of attorney for health and welfare. And so she may put me on as another attorney. Her mum will be fine with that. And we've already talked to her about it, so that we share some responsibility, because we tend to make decisions about Janet together, and we both want to do what's in her best interest. So I think that she, as a single child, may well feel that she wants a bit more someone behind her who's also helping her with decisions. So as well as leading to conflict, it can also support you. And I think I want to say that really clearly. Sometimes having more than one person making decisions isn't just about conflict, it's also making sure that the person making the decisions feels supported. Because if a decision is about, and I've had this conversation with my foster mum, about not being resuscitated or not having or what would happen in the event of. Having just one person making that decision is a lot of stuff to put on their shoulders on your behalf, whereas I think sometimes if that's a burden shared, so it's a good thing.
I think that's a really good point, and you can use professionals for it. So you could use lawyers or accountants to do it. You will generally be paying them to do it as well, so that may come out of the estate, but that can be another way. And often they're then bound to make decisions that are solely in the interest of the client. Where it can get difficult, and it can be a source of tension, is when people say, well, are you making those decisions purely on behalf of the person that you're looking after, or are some of those decisions affecting you or to your advantage? And that can be one of the areas of tension. But if you get disagreements amongst the attorneys, that can cause real difficulty.
And going on from that, me and my siblings shared power of attorney for both our parents. It wasn't until they died that we had our major falling out, and we were all three executors on their wills. That wasn't a helpful thing. So I stepped back from being an executor on my father's will. Having said that, I wish I hadn't. And my dad was very clearly against it, because I asked him before he died, please, I don't want to be an executor. And he said, no, who will protect your interests? So that was a thing from his perspective. But you don't have to accept to be a power of attorney. You can say no. So you don't have to, because someone makes you their power of attorney, you don't have to do it. And if you don't think that that's something that you want to do, or you don't want to be in the position to have to do it, say no. Because you don't have to say yes.
That's a really good point. And if you're not sure about it, a lot of charities will give you really good impartial advice. You will have to go through a lawyer usually at some point, because documents will have to be prepared to go to the court. But actually, charities can be a really good source of advice about kind of pros and cons and what the responsibilities are. And
there are 2 stages to a power of attorney. So you get charged at both stages, so be really careful, because you might think you've got power of attorney when you haven't. You don't have power of attorney until it's been lodged with the court. So at the first stage, you can draw up a power of attorney. Your parent or your person that you're caring for can still have all their faculties and be absolutely fine. But the second stage is lodging it with the court, and you don't do that until you want to have it enacted. So people can draw up powers of attorney years before they need them, but then if they want them enacted, they have to be lodged with the court. So we often come up against people who think they've got power of attorney, but they haven't, because it hasn't been lodged. It hasn't
actually been lodged with the court. That's a really good point. So I suppose one issue might be if someone has power of attorney, or a couple of people have power of attorney, but you've perhaps got some concerns about some of their decisions. So we've talked about things like the court of protection, and although they ultimately have responsibility, going down that route can be very expensive, can be very time consuming. So what do you think would be good advice if you're not sure about some of the decisions that the attorneys are making?
So the first point is the person who appointed them as power of attorney had trust that they would make the right decisions. So even if you don't agree with them about care decisions, that is their right. It's their right to do that. Particularly if there's more than one of them and you still don't agree with more than one of them, then kind of I think you have to bow out, because you weren't chosen. But if, for example...
And I suppose in a similar way, if someone's completely compos mentis and is making decisions you don't necessarily agree with, they're entitled to make those decisions.
Yeah, absolutely they are. And that's covered by the Mental Capacity Act and the Mental Health Act. However, I think if you were very concerned about someone, my first port of call would be to talk to them. You know, when it comes down to it, you could say that you have concerns. It's a duty of someone with power of attorney to take all sides into all kind of points of view into the account. You wouldn't want to make their job really difficult, because having power of attorney is quite hard work. So actually to have lots of people trying to stir the pot all the time can be quite annoying. So it will be something where you sit down and have a talk with them and go, look, I don't agree that so-and-so should have this carer or that carer, or this should be done, and I think it's in their best interests not to have this done. But you were chosen for a reason to be that power of attorney. I think there's an issue. Like my dad always used to say that he'd chosen me because I'd always switch the button off. But that didn't mean that it would make my life easier with my siblings, because they might not agree with me. So he hadn't made it particularly easy for me to make that decision. And in fact, when I've gone into hospital myself, I've chosen the people to make those decisions very carefully. I didn't want my children making decisions about whether or not to switch off life support. I was very clear that decision would have to be taken by someone who was not them.
And I think that's a really important point. And if you're doing anything like a formal challenge, what you've got to remember is they will be judged on whether or not they're acting in that person's best interest. Just because you think a different decision should be made is very different to saying, but they're still making a decision that they think is in the best interest of the person they're looking after. Hello, I'm Dave Dawes. I'm the Learning Director at Future Care Capital. We're a charity that supports unpaid carers to give them the support and the tools they need to look after their loved ones. We're only able to do this because of your generous donations. Please give whatever you can using the support button on the website. Every £1 you give helps us make more and more courses and make them freely available to other carers just like you. Thank you.